It is highly misleading, however, to suggest that because agencies exercise functions that are quasi-legislative, or sort of like legislating, and quasi-judicial, sort of like judging, that they are out of control, or that separation of powers is being disregarded. Legislatures do routinely delegate policymaking authority to bureaucracies, but it is important to remember that they can also rein in any agency that acts too arbitrarily. To be more precise, the legislature can revise legislation that affects the bureaucracy's activities. In other words, the Constitution provides the resolution to the problem of imperial bureaucracy. That is, Congress may transfer legislative powers to a bureaucracy, but it does not surrender its legislative power. If Congress can delegate the power, then it can also take it away. Additionally, there are numerous other mechanisms which the legislature may use to control a bureaucratic agency. It can reduce the agency's appropriations. It can abolish programs that an agency has responsibility for implementing. It can investigate a bureaucracy's activities and force administrators to testify about their activities before an oversight hearing. It can influence the appointment of agency heads or other top bureaucrats. And it can write legislation which forces a bureaucracy to answer for its performance. For example, sunset legislation. Calling the bureaucracy the fourth branch of government means that the view that the president, in his capacity as chief executive officer, is somehow in control of the bureaucracies is grossly inaccurate. However, that does not mean that the chief executive has no means to influence bureaucratic activities. The president can appoint and fire many agency heads and some other top bureaucrats, propose new policies or changes in existing ones which would, if enacted by Congress, affect the bureaucracy's activities, reorganize a bureaucracy, of course subject to congressional approval, and adjust through rescissions and deferrals the annual budget of an agency. Additionally, the president can resist legislative initiatives originating with the bureaucracy and issue executive orders for the bureaucracies to follow. Finally, the courts play a role in holding the bureaucracies accountable as well. Minimally, the federal courts review the decisions of administrative law courts. Any individual who loses a case in an agency's administrative law court is legally entitled to an automatic appeal to the D.C. Court of Appeals. In this capacity, the courts can judge whether bureaucrats have acted within the law and force them to change their practices to be consistent with the law, and second, force a bureaucracy to respect individuals' rights in hearings or other proceedings. Considering the immense tools the constitutional branches of government have over bureaucracies, it is difficult to understand the criticisms of those who complain that the fourth branch of government has usurped the powers of the other three. It must be conceded, however, that bureaucracies have developed their own political power and have evolved means of protecting their turf. Although the Founding Fathers never could have envisioned it, bureaucracies have become another countervailing force in our system of separated powers.